Adjournment request, if any, from item number 1 to 4. From item number 5 to 15. No. Daily list for orders. Item 1.
$55 Huh?
Your Lordship, I'm appearing for the private respondent number 7.
Yes.
There is a delay in filing this street appeal. Delay of 57 days.
55.
55.
Any objection to the delay?
Yes, Your Lordship. Lordship may kindly come to page 6, para 11. The explanation which they have given, this cannot be acceptable.
What is the explanation?
At para 11, basically they have stated that they were in a bedridden condition.
No, it is bad condition, not bad. It should be read as bad.
Bad, yes, but the spelling is bad. Then secondly, they were financially unfit, and there was lack of communication with the council also. So they are not sure whether they were financially unfit or there was lack of communication.
55.
Okay, nobody appears on behalf of the applicant to press this petition for condonation of delay of 55 days. However, the land council for the respondent. The land council for the respondent.
Private respondent.
Huh?
Private respondent.
Land council for the private respondent contested the petition on the ground that the reasons assigned in the application are not good enough. However, on going through the application, we find that a case has been made out for condonation of delay of 55 days in preparing this appeal. We therefore condone the delay. The application stands allowed. The appeal shall be listed on. Give a date after 1 week.
Obligation.
6/8. Item number 2 and 3.
Well, out on last occasion,
Yes.
Lordship was pleased to direct the council for the secondary education, Milord,
Yes.
SEBA,
Yes,
to have their instructions in the matter.
yes. No, but you should have, you were supposed to serve a copy to him.
I don't know. I go ahead and tell.
You don't know the head and tail of it.
But
But I believe you were there when the matter was being argued.
my name is so one in the earlier case, fellow. And one of the two copy has been served.
No, that's a fact, Milord. We apologize for that.
Saikya, you also have to tell us because
No, I have filed the affidavit also.
it concerns the entire education in this.
Yes, yes, yes. I will approach this on.
If they are permitted to be enrolled as a private candidate, no difficulty, they will also not.
The
they should
problem
not-
here is very clear.
Hmm.
Some scrupulous persons are running some tuition institutions, all these things. They admit or they do not admit. At the last moment, they enroll their students for purpose of giving examination through a government school.
That's true.
To stop that, we are doing it.
No, that's true, but.
But one more thing, Lordship.
The student would have.
No, the students are actually, they are either not students, proper students, or they are being fooled.
They are being befooled.
Yes.
Anyway, you file your response.
We'll give a copy.
Lordship, one more thing, Lordship. This cause of action where this IA has been filed in a batches of cases where the act is challenged. In the act, it is the requirement of the private institutions to get registration. Here, it is a totally different cause of action.
That's true. We have seen that.
That's
The
what
last occasion only.
a writ petition may be filed separately, Lordship.
On the last occasion only, Mr. Mazumdar was here
Lordship.
for the Department of Education. He had suggested, but we were only looking for a way out for the students.
The
So that they don't lose 1 year.
The
But
students,
We'll see, we'll see.
Lordship.
Mr. Saike, we'll
And
see.
they are not neither attending any classes. Ultimately, if they come to our domain, Lordship, our record will go back. And it is not doing good to the students also and to the institution also. I'll satisfy this honorable.
No, no. Mr. Saike, perhaps there is some confusion in the matter. Now, for the school to be registered with the SEBA, that is one thing.
That is different,
That is just a minute. School to be registered with SEBA is different.
Lordship.
A school having UDISC number,
Yes,
that's also different because that school
Yes.
has to give a UDISC number to
You-
the students.
Your Lord,
It's a
not to the students.
To the school, 17-digit number.
Yes,
Now, these students, if they can't be admitted in a government school or a provincialized school,
nobody is debarring them. They can straight away come and take admission. There is no stoppage of that.
they can straight away take.
Straight away, we are welcoming students to come to our school.
My lord, these institutions
So
came
this
up,
is a mushroom growth of unscrupulous persons, institutions,
We 100%, we could not have agreed more.
Lordship.
We could not have
Deeply
agreed more.
obsessed.
If this is.
We are trying to cleanse the system. That is why this has
That is
been
true.
done.
So, but we are only looking at.
Those students are neither attending any classes, neither these institutions have adequate number of teachers.
That's right, that's right.
So these students,
if these
without
students-
getting proper education,
Would you open your school?
our open schools are wide open, Lordship,
No, no,
wide open.
but you would be accepting these.
These students, they can come and join us and they will have to study for 9 months or 10 months before appearing in the examination.
All right, you serve a copy. Have
Yes,
a
we'll
copy.
serve
It's a standing concession from my side, Lordship, an undertaking before this honorable court.
My lord, this is the Assam secretary.
That's different.
61.
That we will deal with. They will have to file a separate petition. But here we are only looking for this interim measure,
exactly.
interim measure. So just find out and tell us, Mr. Saikya, if you give that undertaking, I don't think Mr. Chaudhary will have a problem.
And we'll have the instructions, my lord.
Take instructions, serve a copy to him.
They will enroll, Lordship, and they will have to go through the course. No difficulty at all. We'll be more than happy. Because we want proper students to
My
come out
lord,
from the board.
Mr. Chaudhary,
My lord, these schools came up before 2006. The act came in 2006. So there is that another aspect is also there.
There
No,
is
my
no
lord,
issue regarding the
We
act.
all-
here.
we
Act
all
is not a
hope for
burden.
an ideal situation, but it does not happen. Can't help
Ideal
it.
situation for someone to make undue advantage of minting money, that is not we are going to accept.
Mr. Chaudhary, we are aware of the corruption in the educational
So
institution.
who is not minting money, my lord? Who is not minting money
All right.
in today's world?
Mr. Chaudhary, let a copy of the application be served on Mr. Mr.
No, we'll do that.
Mr. T.C. Chutia,
Yeah.
During the course of the day. Stop. This matter shall be taken up for admission. This matter shall be taken up for consideration on your date on Thursday or Wednesday. Wednesday.
Well,
Minting money is okay, Lordship, but not at the cost of the life of the students,
No, we agree 100%.
Lordship.
Something has to be done to cleanse the system for
Absolutely.
future, for posterity.
Next week.
But then we are only looking at. the
One thing is very clear, why they are not having UDICE? Because in the UDICE, the exact number of students, exact number of teachers will come out into the forefront. They want to hide all these things.
But tell me one thing, Mr. Saikya,
Lord.
how would these provincialized schools take admission of students in 9th standard?
In
Because
ninth-
they will ultimately, they shall have to depend on the certification of the school in question. That well, we are giving him TC because we don't have the requisite UDISC number and we can't spoil their lives. So, I mean, you'll have to depend on
So
that.
if they have to take admission in class 9, they have to study in that school for 2 years.
That's right, they will study.
So
only-
at the time of giving the matriculation examination, they come to the government because they are attracting students
I
by
followed that.
unscrupulous means.
Every state has this system.
Absolutely. Lord.
Therefore,
It's a
most-
pan-India problem. It
It's
is
a
not
pan-India problem, but then for them to study in your school, provincialized
We will
schools.
open it, Lordship.
No, for them to study in your schools, you have to permit their admission.
For as a student, we will.
As
What
a-
they want is that they want to only appear in the examination.
Oh, we have followed that. But say a person who has come of age, say who has become 30 years old.
For
would
that,
not-
Lordship, the open school system is already there,
Mhm. I am at a different point altogether.
Lordship.
Now, suppose these students who are desirous of, continuing with their education, and because they mistakenly got enrolled in a school which did not have UDISC number, but they don't want to lose a year. They want to go for matriculation examination, SEBA. So how will you admit them?
Lordship, may I just point out one? One is UDISA and SEBA affiliation. They can have other boards affiliation also. They have not affiliated under SEBA also to prepare the students for appearing in the examination through them.
Mr. Saikia,
For that, this act has nothing to do.
for the timing, Saikia, Mr. Saikia, you please forget about schools.
Lordship,
Forget about the schools not having
Lordship.
registered, no UDISC number. They are not registered with the portal. They are completely out of the radar.
Lordship,
Follow. Now, some students must be genuine students out of them.
Lordship.
So if they want to get admitted in provincialized schools for class 9,
Open. It is
But-
open for them.
but how would you ensure that they have passed their 8th examination?
8th examination. That Lordship will have to examine at the time of admission.
Please examine that. That is
Yes,
my,
I'll look into that.
that is my
that is-
only concern.
That is a very
Suppose
relevant situation.
Suppose Mr. Chaudhary's client, I mean, some of these students, his clients are schools, but then
Schools,
we are not concerned with schools. We are concerned with students.
Lordship.
So if those students try and take admission in your schools, government schools,
Yes, Lord.
how would you ensure that they have passed 8th standard?
Absolutely, Lordship.
Therefore,
I'll look into that
That
aspect also.
mechanism, if you say, we will go by what you say 100%. That
Even in class 10 also, they can take admission. Both the classes are open for them.
But on
Now,
whose
Previous
certificate?
class, whether they have properly studied or not.
Although we have followed it, it's a concession, it's a good concession. But on whose certification would you rely?
I'll take
The
it.
student's own certification that I have passed 8th.
Private institution for that is if a class 9, all students have to register their name with the SEBA. In class 9, if it is not registered, then he is not allowed to fill the exam.
Mr. Chudia, you are on.
Lordship, I'll take instructions on
Mr.
this.
Chudia, you are on a completely different plane now. Mr. Saikia, please find out.
I'll find out.
The only concern of this court
Lordship.
is for students. You
I-
can't, we
I
can't
fully,
across the board.
I understood Lordship's query and I'll get
Mr.
instructions.
Saikia, across the board, we can't say that every student would be a fake student. We
Lordship.
can't say that.
No, Lordship.
We can't say.
No, they are victims in my humble submission.
You're right. They are victims. And in fact, to tell you a fact, I had introduced a system of penalizing these schools for taking admission. And many a times we have come down heavily.
I'll be more than happy, the state will be more than happy if Lordship imposes penalty on the schools if it is found to be on the wrong.
In some other case, Mr. Saikia, but you first guarantee the welfare of the students. you
I
would like to
fully,
continue.
I fully appreciate Lordship's view and will fully cooperate with this.
All right. So it shall be considered again on 30th.
Lordship.
Mr.
Okay.
Chaudhary, ask your junior to serve a copy today.
Just now we'll do, Milo. Deep learning.
Highly obliged, Lordship.
Item 4.
120.
Delay of 150 days in preparing this data film.
You'll have to address us on merits.
Today, Malo.
Yes, today. I had indicated in the beginning that
Yes.
for these matters, we would examine the merits of the case.
Yes.
If at all the case has to be dismissed, then we will condone the delay and then hear you and dismiss. Otherwise, we'll have to issue notice and a consolidated notice shall be issued. So there is no, the matter is not lingered unnecessarily.
Yes.
So therefore, you are not ready on merits.
Today, for order. Today is listed for orders for condonation of delay. Let it
All
come on
right.
Monday, Malo.
Technically, you are all right.
Yes,
But why do this delay? We will be condoning the delay,
yes, ma'am.
but then you'll have to address us on merits.
Yes, Malo. The learned single judge has not considered the impugn mine with my lord.
If you're ready, we are not forcing you to argue because this is a new system which I would be introducing.
Then
in
on
the
Monday,
bar.
my lord, Monday or Tuesday. Regarding on admission, Malo.
The land counsel for the applicant. Land counsel for the applicant / appellant seeks a short adjournment to get ready in the matter. Re-notify on, give a date on Monday.
Next week,
Monday.
yes. 27.
Just go through it. It must be a 5-6 pages judgment
Yes,
of the land single judge.
yes.
Go through it. We will also go through it
Yeah.
and then we'll pass on.
Item number 5.
4,475.
May I plead your lordship, praying for delay of condonation, my lord, 44575 days, my lord.
No, we have some reservation with respect to the maintainability of this writ appeal. You may have been adversely affected. It's the same foreigners court, no? That
My
you
lord.
cannot go before the
My lord.
before the civil court for determination of your
My
right.
lord.
And then you are not a party. That is one thing. If you are adversely affected, that judgment is of anterior time. You could, that must have been questioned a long time back. I think it's the same matter, no?
My lord. Same matter, but my lord, earlier petitioner,
Anyway, you respond, let the consolidated notice
my lord.
in the IA as also in the writ appeal is accepted by Mr.
J. Paying, my lord.
Mr.
J. Paying.
J. whatever.
PAYENP.
J. Pine.
Yes, Mr. For respondent, but
The necessary response affidavit on behalf of the concerned respondent may be filed by the next date. Re-notify 2 weeks.
only one
Obliged,
point
my
I'd
lord.
like to point out, my lord.
No, one, the delay is absolutely difficult for us to overcome, number one. Number two, on merits also. So
Only,
just to put an end to it,
yes,
you argue or even on the merits, you
Yes.
file your affidavit.
Yes. Only one point I'd like to point out, my lord. Because in the initial proceeding, they were not party, my. I don't think
Did
they
I
had-
not say that in the beginning? Did
Yes.
I not say that in the
Your
beginning? I
lordship
told
has-
it, no.
They
That's
have
the
not-
question, but
they have-
say the provision of law, you're aware. Long before Shah Babu Khimji, 1964, even if a person is not a party in a writ proceeding, but the order or the judgment adversely affects him, he can file an appeal.
Yes,
So that's all right. But then if the appeal, the grounds of appeal is non-existent, if this is a judgment of yesteryears when this must have been challenged by somebody who was adversely affected, and if there would have been a seal of approval, all these things you'll have to find out. Otherwise, there'll be duplicity of judgments. Agreed? So therefore, we are not dismissing the IA. We want to cure this entire thing of unnecessary, appeals pending before this court. Have you followed what I have said?
yes, I understand.
Look at the judgment, try and find out from your records whether this was ever challenged by anybody on principle. Right?
Obliged.
Obliged.
On 13.8. Item 6.
Merit of. 73 days.
Item number 6.
Made his minutes. This IA is for condoning the delay of 73 days, my lord.
What is the issue?
My lord,
Always give me the. Yes. 1 second.
Filling up the post.
We are more than inclined to condone the delay only when you satisfy us on merits, prima facie.
my lord, admittedly, in the writ petition,
Now let's see the judgment.
Page 94, 95.
page 94, my lord. Well, admittedly, what has happened here is that the writ petitioner did not make the candidates of the select raise as a list as a respondents in the writ petition, my lord.
This is page.
Page 94. 94.
94, my lord.
Yes.
At para 13, my lord, that relevant portion is at page 98, my lord. Down below at para 13,
Second once.
my lord.
But you did not secure 50% minimum marks.
I did not, my lord.
Qualifying marks was 50%. What weightage would you expect?
My lord, I had served.
Weightage comes only when you crossed the threshold.
The threshold, my lord. My lord, another writ petition, the single judge had said a due weightage should have been given. But my lord, I had rendered 12 years of service, my lord. I had taken special,
Would that make a difference?
I had taken special
Just delay.
73 days, my lord.
Let consolidated notice in IE as well as in writ appeal be filed positively, be issued. You appear for the respondent.
For the High Court in this matter, Malad.
No, High Court is nothing. No?
Private respondent was not made a party. There is very also another,
That's all.
there is no challenge to the appointment out of that.
That is. But then we'll see.
He is basically asking for weight.
He can't know.
Yes.
So therefore notice goes to whom? You have not even made the selected person a party.
My lord, that is admittedly that has been,
Then on that ground alone, your IE also will be dismissed. Because he stands when appointed.
my lord, at the
He
time, of-
stands appointed. So main party would be him.
my lord,
Amend your prayer.
my lord,
Amend your prayer.
my lord.
He should not have been so indulgent. Nonetheless, we are giving you that.
I'm so grateful, my lord.
You are Mr. Sharma.
R. Sharma, my lord.
Mr. R. Sharma, learned advocate for the applicant appellant submits that he shall file an additional affidavit seeking impediment of the private respondent who has been appointed on the concerned post. For the aforesaid purpose, he seeks a short adjournment, re-notified 2 weeks.
11-8.
Obliged, grateful, my lord.
For petition, item 7.
Have legal loss. By the impinged judgment, my lord, the case of the petitioner was rejected, my lord, by virtue of a decision of the division bench. But another division bench, my lord, first author order, my lord, I am relying on to that, my lord, though I could not have annexed. Epilepsy.
Give us 1 minute.
Page 1.
No, JLT though, Anwar. JLT lo thori pori ki baat kar.
Name. Jai Barboya.
Jai Babuyan.
Yes.
So, my lord, by
Just
virtue
a
of,
minute, give us a minute.
my lord, my. Dilip Chaudhary.
Which judgment have you given?
My lord,
All division bench judgments are against you.
not, this Dilip Chaudhary is against me.
And
That
even Kuladhar is against you.
My lord, this judgment somehow it can save me, my lord, since my application is also pending before the government, my lord. Only in that light of that, my lord, if a lordship consider.
That's a general statement that the government has given promotion to ex-cadre people also. We don't know.
My lord,
If the matter is pending before the government, don't press this appeal. Otherwise, this order would be, order by the single judge would stand confirmed. I mean, there are no issues here.
my lord, only one thing, my lord.
Have you made a statement? Are you in a position to make a statement that it is pending consideration with the state
Yes,
government?
yes, I have annexed also that document. my lord. I have annexed, my lord, lordship will see at page. No, 63, 64. 53 and 56 page, my lord.
But even if the government does it, you would be marring the seniority, you will be disturbing the seniority of another. That will be challenged and you will go.
My lord, similarly situated persons have been already appointed, my lord, as like standing like me. I have annexed in the read petition also. So may I pray, my lord, in the light of the judgment which I have given, my lord, my case may be considered, my lord.
Only thing notice issued. Is it coming for the first time?
Lordship,
Let's see, on this issue only will
Lordship.
notice. Take that.
In the
In the meantime, nothing.
No, my
We are
lord.
inclined to
No, my
dismiss
lord.
it
In the meantime, I'll file additional affidavit bringing the judgment into record.
That's not required.
Lord.
Judgment can always be passed.
Which judgment?
Just now
This
I
one.
have given, my lord. This one. If desired, my lord, by your lordship.
Devon Chandra.
I don't think it's a correction. I don't.
This is the Dilip Chandra.
Dilip Kalpar, I know. And they will Kuladhar in. Otherwise also in principle.
लेके रहो लेके
Take that.
Yeah.
You have heard Mr. J.
I bow.
You have heard Mr. J. Borbhoya, learned advocate for the appellant, who has questioned the judgment dated 10/6/2025, passed by a learned single judge in this court in WP bracket C 7535 of 2022. The appellant was regularized in service by an order dated 39/2005. But it was only against a personal post. It was only against a personal/supernumerary post held by him during his tenure as a muster roll worker since 1980. After his regularization, a provisional gradation list was published sometimes in the year 2019, in which his name had figured at serial number 2. That was only a provisional list. But in the final gradation list published on 29/7/2022, the name of the appellant did not find mention. Under the orders of this court, passed in WPC number 5910 of 2022, a representation was given by the appellant before the authorities of the directorate for rectifying the gradation list. But the same was rejected on the ground that the appellant was never engaged in the service. In fact, it was argued on behalf of the respondent before the writ court that after the regularization of the service of the appellant herein, the post, the supernumerary post which he had held prior to regularization was abolished. It was abolished. Thus, for all purposes, he was treated as an ex-cadre employee. And thereafter, there was no decision of the authorities for encadering his services. True it is that the appellant was drawing a higher grade pay than many of the persons in the gradation list. But that would not lead to the acceptance of his demand of being part of the gradation list of the cadre of grade 4 services in the directorate. The learned single judge, while dealing with the issue, relied upon two division bench judgments of this court, namely Dilip Talukdar and 21 others versus State of Assam and others, 2017, bracket 2, GLT 135, and Uladhar Talukdar and others versus State of Assam and others, 2021, 0, Supreme Court, Supreme, bracket Guwahati 94, wherein it was held that the regularization of a grade 4 worker against a personal post would not see his entry in the in-cadre post. Which is the feeder cadre for any higher cadre post. Consequently, the writ court dismissed the request of the appellant. Mr. Borbhuyan, learned advocate, has however submitted that very recently, in a case of this kind, a division bench of this court took note of the fact, though based only on the submissions made on behalf of the parties, that several such persons were encadred, even though they were regularized on supernumerary posts and directed that since the government is considering the cases of such persons, the writ petitioner therein, the appellant therein could await the decision of the government, who in turn was directed to pass an order without being influenced by the orders passed by this court in several of the writ petitions. Let notice be issued to the respondent. You're accepting it?
I can accept notice.
Accept the notice.
I will.
The notice to the respondents is accepted. Let notice be issued to the respondents. Let notice be issued to the respondents. The notice to respondent is accepted by MS.
Sharma.
Ms. S. Sharma, learned advocate. Let an affidavit be filed, let the response affidavit be filed confirming such statement of Mr. Borbhuyan that similarly situated, that the government has taken a decision in the case of similarly situated persons of encadering them and putting them in the gradation list. The affidavit must be filed on or before the next date. 3 weeks?
There no one has been infected. What he's saying is that persons who have not been infected have been promoted.
Have been promoted, so it means the same thing that.
No, but he has said that who are always
So promotion in catering is only for the people with promotion to get. So by what mode they have in catering, then let them know. I don't think this is a correct statement. But then let's see. Once that statement is brought to our notice, then we must.
Open a
take the
Pandora's box if the government does that.
Hmm?
It'll open a Pandora's box if the government.
No, that's all right. So you say that. You say that nothing of this kind has been done.
My lord,
See,
I-
the government would have considered granting promotion to the higher cadre post without in catering, but then that would also lead to anomalies.
Don't.
And how could that be done without in catering them? For the reason that it would cause anomalies in the gradation list, and the issue of seniority would come up. So therefore, you have to deny this.
I have annexed
there is a-
already,
there is
my
a-
lord.
there
In
is
the
a-
read petition, I have already annexed.
No, there is an order passed by a division bench of this system.
Yes, yes. Right.
Passed by the former CJ. So we must take it into account. All right.
Of license.
20th August.
2-0.
Item number 8.
Please, Your Lordship. My lord, before arguing my case, my lord, I am apologize before Lordship to inform you, my lord. Inadvertently, my lord, respondent number 4 was, my lord, not make a party.
Inadvertently, what did you do?
Transport department was not make a party, my lord, due to my mistake, my lord.
Which department is to
But-
be made a party?
My lord, Guwahati High Court already main party, but subsequently the writ petition honorable court call my lord the transport department by making a party. So inadvertently I was not. I am today, if your lordship permit me, today I am going to file a IA for implementing my lord. My fault. I'm sorry for that, my lord. In this case, my lord, actually, my lord, we are challenging the honorable single bench order. Because of that, I am one of the candidates for the appointment of driver in Guwahati High Court, my lord. And I am the waiting list, my lord, in cell number 5, sorry, 6, and private restaurant number 5, my lord. And my case was not considered, but after going through the RTI, it is revealed that restaurant number 5, 3, my lord, he is not qualified, my lord.
If you were not. Very well, what do you want?
My lord.
We have said, though you may not, you may have a weak case, but we have certain reservations about the observations in the single judge's judgment.
My lord.
That transport vehicle and professional driving license
Yes,
are two
Lord.
different things and there
Yes,
is any confusion.
Ma'am.
So if that person was a minor, let's see, you correct your petition. He has been
My lord, today I am going to file, my lord, ready already, my lord, your lordship.
as prayed for on behalf of the appellant, re-notify
My lord.
Tuesday.
Yes, my lord. Today I am going to file ready, my lord.
Today, we are not hearing, no, so.
Yes, sir, I'm sorry.
It has to be given,
Why?
Tuesday or Wednesday.
Tuesday, my lord. Much obliged.
Wednesday. 30th.
The reasoning was not very convincing.
Item number 9.
And we'll also issue notice to. Yes,
May please, Your Lordship. This appeal is preferred, Lordship, against the Honorable Single Judge's order dated 8/5/25, Lordship. It is in page 25, Lordship. 24, Lordship. Basically, we are agreed by the direction contained in paragraph 24 and 25, Lordship. It's in, starts from, Lordship, page
you have
38.
the state.
Lordship, I am for the state, Lordship. If Lordship permit me, I can read the paragraph 24 and 25, Lordship.
So representation. Mandamus submission. By representation.
For instance, itself,
Like notices we issued. Two. This is the memo.
Page 24. That's a page.
To response number 1 to 3. On steps being taken by the appellant within a period of 2 weeks, both modes, returnable on. Give a date, we have given 2 weeks, returnable
13,
5th week, 5th week,
50.
See, I have policy.
will not do anything.
Otherwise,
27.
You tell the authorities that notices have been issued, the court is in ceasing of the matter. Without hearing, we are not going to stay.
27-8.
The ball is in your court, Mr. Counsel.
Lordship,
If they file a representation pursuant to the orders of this court,
Right.
you can always tell the authorities that the matter is pending consideration before the appellate court, and the appellate court has issued notice.
I'll do, Lordship.
So therefore, no need of stay.
I'll do, Lordship. I'll do. Oblige, Lordship.
14.
Therefore, I will. Yes, I will not pass any order. This is item number 10.
May it please the lordships. My lord, I have a limited prayer here.
We are surprised.
What happened, my lord?
We are surprised at this order,
Sorry?
but we are surprised at this order,
Yes.
but the fact remains that since it was contested heavily by the parties, therefore notices have to go.
Yes.
We are inclined to condone the delay.
Exactly. I'm
It is
deeply
in
obliged.
for review.
Yes.
What benefit would you get in review?
My lord, because if certain points, those were not considered, if it goes to the root of the matter regarding
Would be
signature.
the point, you were the loanee,
Yes,
your loan went bad,
yes. My lord,
therefore the authority found it that you were jointly and severally liable.
true.
That's an open and shut case.
That's,
So in review, why can't you? There is no provision of appeal.
the provisional appeal is there.
So why are you contesting this
Provisional
review?
appeal
And
is
then
there.
the limitation.
Yes. No, so every stone to be unturned by going there, lordship knows it, my lord. Collateral securities and all that is there. And it is a loan regarding to commercial vehicles. And those are in their custody itself, lying. I have not taken delivery since then. They can recover the amount from there also. And some amount was paid, but this was against the
We are
contract.
not on that issue. Mr. Mahanta.
KK Mahanta.
Mr. KK Mahanta, we are not on that issue. We are only telling you that why do you intend to contest this review petition? Review, you're not going to get any.
Well,
relief.
maybe I take your lordship. Well, maybe I do not say that he has an absolute chance of coming out successful.
Only 24
then-
days. See, we would have allowed it in a jiffy, in a second. But then it was contested by the gas company, no, by the bank.
I'm
bank has to be
not
noticed.
the bank, my lord. I'm the gas company.
No. It was, your application for condonation of delay of 24 days was contested civilly by
the bank.
HDFC.
By the
That's
bank.
what I'm saying, no.
Yes.
Otherwise, we would have condoned it just now, 24
Yes.
days delay.
Yes.
But I
Let
think
the
you
short notice go, my lord. Then let the tribunal take the call, ultimately on merit.
He's lucky that the tribunal has rejected. Delaying the inevitable. Yeah, he has to file as he'll file again.
What is the provision against the order passed by DRT? Apart
DRT
from review,
for review, yes.
apart from review, what else?
Apart from review,
I think.
17.
appeal. Appeal lies.
Appeal,
Appeal
abandon
lies.
this.
Apart from review, appeal lies directly.
So abandon this.
My lord,
It will be easier for you. And we are only suggesting, otherwise, here we can only issue notice.
my lord, I appreciate your lordship's point. But then a remedy is sought here, it is open for him, that he is trying that.
Okay, so therefore, we are a little, jittery about issuing notice in a matter which concerns only the delay of 24 days.
Yes.
So otherwise, it doesn't look nice. Yeah, but it has been contested here.
That way you should notice that.
Yeah. against an order passed by the DRT, the petitioner had filed a review petition, but only after a delay of 24 days. The application for condonation of delay, only after a delay of 24 days. The application for condonation of delay was, however, rejected by the impugned order dated 13/5/2025. We would have otherwise condoned the delay of 24 days. But considering the fact that the limitation petition preferred by the petitioner was contested by the respondent gas company, we
Respondent,
only
respondent bank.
sorry, respondent HDFC Bank, sorry, respondent HDFC Bank, we only deem it appropriate to issue notice to the bank, subject to the steps being taken by the petitioner within a period of 1 week, both modes returnable in the 4th week. Unnecessarily delay, Mr.
Well, I have taken your losses, so I have instructed my client accordingly, but then let him have this instruction too. Remedy available under the law.
All right.
I'm deeply obliged. Well.
18 August. Item 11.
The fresh case.
Especially in criminal case and removed in the.
May I please, my lord?
Yes.
My lord, this is a matter relates to removal from service, my lord. My lord, the prisoner, the appellant before your lordship, was work.
Yes, yes. Continue.
The appellant before your lordship was working as a sub-inspector of police.
Hmm.
And my lord, it is alleged that, my lord,
You are a trigger happy police officer.
my lord, the allegation is that he has shot on one of his colleagues, my lord.
Sometimes they go as per the fact. They don't get in.
I think they don't respond. I make.
They don't catch on very fast.
Wait, sound sense? There.
No, no, it sounds sense, but it depends upon the conflict. Yes.
Yes.
My lord, my writ petition was dismissed mainly on 2 grounds, my lord. That the
You
writ
continue. We are looking
Yes.
at the file. We are not stopping you from arguments.
Yes, my lord. My lord, the writ court has dismissed my writ petition mainly on 2 grounds that the writ petition, the writ court cannot reappreciate the evidences. And my lord, with regard to acquittal in the criminal proceedings, since the mode of proof is different in the criminal proceeding as well as the disciplinary proceeding, my lord. Therefore, the writ court has dismissed my writ petition, my lord. My lord, my submission is that, my lord, the criminal court which has acquitted the appellant, my lord, it says that, my lord, although the word is benefit of doubt, but my lord, nothing is there, my lord, and the main witness who's claimed to be as a eyewitness, my lord, in the cross-examination in the criminal trial, my lord, he says that, my lord, he was not present. And my lord, there is no injury report, my lord. Although the allegation is of bullet firing, but there is no injury report exhibited in either during the disciplinary proceeding as well as during the criminal trial, my lord. And my lord, the evidence, what is supported, and my lord, the main problem is that, my lord, the appellate authority where the appeal was filed, my lord, had not looked into all the aspects because my lord, the writ court is very limited jurisdiction, I know, my lord, but the appellate court has not looked into any aspect of the matter, my lord. Only 3-line finding, my lord, that he has gone through the report and find that everything is all right, therefore the appeal was dismissed, my lord.
The appeal was against the order passed by the disciplinary authority, not the writ court.
No, not the writ court, my lord. They are,
You
my
were
lord.
saying writ court.
Yeah, no, I'm sorry for that.
We are.
No,
hearing the appeal.
I'm not, my lord. The appellate authority against which the order of removal, my lord. I'm sorry for that.
You don't have a case, sir. The difficulty is this. You know, the person whom you shot as an officer, he is your friend. Perhaps you asked only one question from him during the trial. Or, I mean, during the trial, whatever had happened, but during the departmental proceeding, he was a witness. You cross-examined him only to the extent of whether he was drunk on that day.
That
He
is the-
said no. That's all.
That is the
So
one.
therefore, you don't prove anything. at the trial, in the criminal trial, it was, you said that after all, he's a friend and he was drunk. He never intended to shoot at me, and therefore benefit of doubt was given to you. With respect to the intention of causing such harm, there was no injury report, all right, but there was no denial that no such occurrence had taken place. So which force, which discipline force will keep you in service? On a minor verbal scuffle, you take out your pistol, you cock it, you aim it, and you fire. And against whom? A friend of yours with whom you're drinking. Nothing less than dismissal. They have only given you removal.
Removal from service.
The law is against you. The facts are against you. You are a fortunate person that you have been acquitted because you had a good friend in the victim. All right. So we dispose of this petition. All right, Mr. E.K. Gupta. Who appears for the state?
I am appearing well.
You are Mr. D.K.
Sharma.
Heard Mr. Gupta, an advocate for the appellant, and Mr. D.K. Sharma for the respondent. The appellant is agreed by the judgment dated 22/2025, passed in WPC 903 of 2023, wherein the order of the disciplinary authority, comma, removing the appellant from service, and the appellate order, comma, sustaining the punishment imposed upon the appellant. What did I say in the beginning? Have been ratified and sustained. It appears that the appellant had opened fire from his service weapon at one Joydev Nath from a close range, as a result of which he suffered grievous injury, but was saved because of the timely medical intervention. An FIR was lodged in which the appellant was arrested, but was later released on bail and also reinstated in service, pending the departmental proceeding against him, which was initiated on the charge of his having shown a conduct which was not befitting a police officer and trying to kill a colleague inside government quarters by the government weapon. In the course of the departmental proceedings, the evidence was examined, including the witnesses were examined, including the victim / Joydev Nath, who supported the accusation. The disciplinary authority, on finding that the appellant, being a member of the disciplined force, had committed such an act which could have killed his colleague, found him guilty. And found him guilty. It was considered to be a criminal misconduct. he was saddled with the punishment of removal by the disciplinary authority. The appeal preferred by the appellant before the Deputy Inspector General of Police, bracket SR Assam, Silchar, was also dismissed. However, in the meantime, the appellant got an acquittal on benefit of doubt from the trial court. The contention of the appellant before the writ court was that with the acquittal of the criminal case against the appellant, he could not, he ought not to have been removed from service. In support of this contention, a decision of the Supreme Court was cited, namely Ramlal versus State of Rajasthan and others, 2024, 1 SCC 175, wherein the Supreme Court had interfered with the penalty in the disciplinary proceeding of the party on the ground of the charges in both the proceedings, namely disciplinary proceeding and criminal proceedings, to be absolutely identical. The learned single judge thereafter proceeded to examine the case in detail and found that the trial court, which had acquitted the appellant, had observed that the victim had made a departure from the accusation and did not state emphatically that the action of the appellant herein was voluntary and intentional. He also stated before the trial court that mercy be shown to the appellant herein, as he was a friend of the appellant. Thus, there be no evidence on record before the trial court to confirm whether the firing was accidental or intentional, benefit of doubt was given to him. And he was acquitted of the offenses under sections 326/307 of the IPC 1860 and section 3 of the PDPP Act 1984. The learned single judge, however, concluded that the standard of proof required in a criminal proceeding is absolutely different from the standard of proof required in the departmental inquiry. The same charge and evidence may lead to different results in the two proceedings, but that would not be a ground for interfering with the decision of the disciplinary authority in a departmental proceeding. In a departmental proceeding, the charge is to be established by way of preponderance of evidence, whereas in a criminal case, it is required to be established beyond all reasonable doubts. beyond all reasonable doubts. It is cadet question now. That a court of law, that it is cadet question now that a writ court shall not act as an appellate court and reassess the evidence led in the domestic inquiry, or would interfere on the ground that yet another view is possible on the basis of materials placed on record. What a writ court is to see is whether the inquiry against the delinquent was conducted fairly and properly, and that the findings were based on evidence. The issue of adequacy of evidence or the issue of adequacy and reliability of the evidence is not required to be gone into. Is not required to be gone into. The disciplinary authority in the case of the appellant found that a member of police force ought not to be so trigger happy so as to train his gun, train his weapon at his friend over a minor verbal scuffle. There was no denial of the victim in the departmental proceedings that the appellant had not opened fire. Members of police force are required to display a disciplined conduct, or else it would be unsafe to leave the administration of justice on them. Members of the police force are the first responders in case of any trouble. Taking these facts into account, the learned single judge ratified, learned single judge agreed to and ratified the decision of the disciplinary authority in imposing the penalty of removal of the appellant from service. We find no good reason to interfere with the judgment of the learned single judge. Thus, we dismiss the appeal.
Right.
Item 12.
Yes.
My lord, appellant before your lordship, my lord, is a LP school teacher. He was, my lord, inadvertently, my lord, overstayed in service.
Inadvertently.
Yes, sir.
How is that possible?
My lord,
When you join a service,
yes,
when you join a service, you may forget the date when you join, but you will remember the date when you retire.
normally,
This happens.
normally it is so, my lord, but
I would
Yeah.
not know. I would not know when my brother joined as judge. But I would definitely know when he would retire.
Yes, my lord. No, obviously, my lord, it is normally, my lord, we think so, my lord. But here, my lord, there is a, my lord, twist in this matter, my lord. Because, my lord, when this petitioner before your lordship, now appellant joined in service, my lord, he was to retire, my lord, at the age of 58 years, my lord. But without, my lord, informing any notice, my lord, directly to him, my lord, government, my lord, once it was made 59 years, then it was made, my lord, 60 years, my lord. Without any notice, my lord. It is only he knows from the, my lord, the public mouth that, my lord, is.
Is
So-
it believable?
Yes, my lord. Therefore,
Is it believable, Mr. Counsel?
my lord, some extent believable because it is a, my lord,
So therefore, the single judge gives you plenty of relief. Says that no money for the 3 years that you overstayed in service would be recovered from your pension.
yes, sir.
But still you have come to this court challenging his
My lord,
judgment.
this is the,
We might set that aside also in view of your case not falling in the category of cases where Rafiq Masih operates.
yes, my lord.
So therefore, you have come for more relief. You would
Double benefit.
you will get that relief which has been granted to you by the single judge also removed from
Yes.
the records.
But only thing is that, my lord, here indirectly, my lord, again recovered, my lord. Because for my pension, my lord, I have to no service to be rendered, my lord. When I require
See,
pension,
we ratify the judgment of the single judge on the ground that he has taken a very liberal view, but has considered that for all the period of overstay, you had worked as a teacher.
yes, my lord.
But you don't fall in that category. This was a concession given to you. But where is the mistake of the single judge in saying that it should not be counted for calculating your pension and other benefits? And you have filed an appeal. We are surprised.
Yes, my lord. Here, my lord,
I think you should have run away with you should have disappeared with the order passed by the learned single judge. That was more than what you could chew.
my lord, only thing is that, my lord, my lord, it is indirectly, my lord, recovered, my lord. Because, my lord,
What is being recovered?
Supreme Court said that, my lord, when overstay, my lord, salary is given, my lord, it is just like his labor, my lord, because he worked and he got, my lord. But for my pension, my lord,
If I were the single judge, I would have initiated an inquiry because you maneuvered. You did not let the authorities know that your date of birth is 58.
my lord,
You
it is-
allowed it to remain
my
61.
lord, it is their admitted position, my lord, in their own affidavit that, my lord, it is admitted, it is their mistake.
Anyway, aren't you satisfied with the order passed by the learned single judge?
Lord, I personally, my lord, legally, my lord, it is not so, because, my lord, it is admitted in their affidavit.
We may set aside that order and we take back that relief also.
Lordship, kindly have a look,
Just a minute. Have you followed what the court has said?
yes, my lord.
You don't fall in the category of such persons from whom recovery should not be made. You are not in the category of Rafiq Masih.
Yes, my lord. Grade 3, my lord, I am employee, my lord.
You're grade 3. That
Yes.
is for grade 4. You're grade 3.
Grade 3
Then
and
perhaps you come in that category.
Yeah.
So therefore, no recovery of salary from your pension because you work.
Yeah.
Nothing more.
yes, my lord.
We are not going to give you anything more. And we will observe that it was your doing.
Kindly, my lord, matter may be hard, my lord.
Please hear. We will hear. So what have we been doing all this while?
Lordship, kindly have a look, my
Hearing?
lord.
Hearing.
No, I don't.
No, we'll decide it now. What hearing? We are hearing you.
Lordship, kindly, have Supreme Court judgment, my lord, page 75, my lord.
Page 75.
75, my lord.
I don't know if stipendary teacher is a grade 3. Stipendary teacher, I don't know if that is grade 3. And the government will have.
Grade
to
3, my lord.
Yes, with judgment.
My lord, this is the, my lord, judgment of the state of Bihar and another, my lord.
Pandit
Pandit-
Jagdishwar Prasad. We
Yeah.
are aware of it.
Yes, my lord.
We are aware of it.
My lord. Lordship, kindly look, page 77, my lord, paragraph 7, my lord. I am just showing the date of, actual date of retirement here quoted, my lord.
Page 77.
Page 77, paragraph 7, my lord. According to the first mentioned date of birth, the respondent ought to have retired
No,
on.
this paragraph 7, just hold on for a minute, 7, 5, 6, 7, yes.
7, my lord.
Hmm.
According to the first mentioned date of birth, the respondent ought to have retired on 28/2/2002, but he retired on 29/2/2004. According to the other mentioned date of birth in his book, as noted herein earlier on 4/12/2004, a reasoned order was passed by memo number so and so in the context of an order dated so and so passed so and so, so and so, my lord. Just I am showing the date of actual retirement, my lord. Now, lordship, kindly have a look the same, my lord, judgment paragraph, my lord, 24, my lord. Paragraph 24, paragraph 24, my lord, page 80, my lord, running page 80.
Yes.
Considering the fact that here no allegation of misappropriation or fraud which could be attributed to the respondent, and considering the fact that the appellant had allowed to respondent to work and got work done by him and paid salary, it would be unfair at this stage to deduct the said amount of salary paid to him. Accordingly, we are in agreement with the division bench decision that since the respondent was allowed to work and was paid salary for his work during the period of 2 years after his actual date of retirement,
This has been granted.
without raising any objection whatsoever, no deduction would be made for the period from the retirement dues of the respondent. Now, lordship,
Mr. Borbuya,
my lord.
why are you reading this? This has been granted to you, no?
Yes, my lord, granted. Only thing is, my lord, even otherwise, my lord, if my now, my lord, arrear pension is not given, so indirectly it is recovered.
What?
My lord,
Where is that? This judgment says so that.
yes,
should
yes,
be
my lord,
declared
it
for
is said
contempt.
so, my lord. Lordship kindly look penultimate paragraph operative part, my lord. Lordship kindly will look page 28, my lord.
Para 28.
Page 28, my lord, para 24, my lord, of impugned judgment, my lord. Current impugned judgment.
Para 24 of the impugned judgment.
Page 28, my lord.
No, show us from this judgment that you are citing that no recovery of salary from your pension. Agreed, you have got that.
Yes, my lord, this is my lord.
Where is the direction or the judgment of the Supreme Court that it should
Yes,
be,
my lord,
it should be
page 30,
included
my
in
lord.
your pensionary benefit?
Page, my lord, paragraph 30, my lord, of Jagdish Pandey, my lord. Paragraph 30, my lord, running page 81, my lord.
No.
I think your case is that you want your pension from 2018 also.
18, my lord.
That is what you say.
Yes,
Even
sir.
double benefit.
From the,
Mr. You have cited this Jagdishwar Prasad, no? State of Bihar versus
yes,
Jagdishwar.
my lord.
And you read paragraph 7.
Paragraph 7 just showing, my lord, date of
And
retirement.
you also.
And my lord, not to recover, my lord.
If you continue arguing in the way you have thought that you will address the court, that is different. But when the court is asking you, please bear with it. You showed us paragraph 7 to show the similarity of the facts.
Yes, my lord.
Right. You also read paragraph 24.
Yes, my lord.
Now read paragraph 30.
Yes, 30, my lord. There is another aspect in the matter, although we are directed that the excess amount paid for 2 years to the respondent as salary cannot be recovered from the respondent, but we make it clear that for fixing the retirement benefit, the period of 2 years in respect of which salary was received by the respondent cannot be taken into consideration, and the respondent would be entitled to fixation of retirement benefit as on the date of his superannuation, that is.
Yeah, now you have followed.
Yes, my lord.
So still you argue.
No, this is, my lord, from original date it was given, my lord, 2002. He's
Anyway, we are dismissing your.
Lordship, kindly will look page, my lord, paragraph 17. I may be allowed to reiterate, my lord, for my clarification, my lord. Paragraph 7, my lord, as
Of
far
what?
of this judgment, my lord, page 77, running page, my lord.
Yes.
Paragraph 7, my lord, his actual date of retirement is 2002, my lord. And here also given, my lord, his retirement.
2002? Here the date of retirement 2018.
Actual, my lord, no, my lord, here, my lord, in this judgment, my lord.
Otherwise also.
And he was,
I would have a judgment, I would not have a. And he has read it and he's not. Mr. Borgoya, we feel, we are very frank.
yes,
We
my lord.
feel that you have understood what we have said, but you're feigning ignorance.
Yes, my lord, Paras, my lord. So,
Yes, sir. You're feigning आप ऐसा पोज कर रहे हैं कि आप नहीं समझ रहे हैं क्या हम लोग कह रहे हैं. अब आप यस कह रहे हैं उस पर.
no,
पैराग्राफ 30 जब हमने आपको पढ़ा दिया, if we have asked you, you have yourself read it, still you're arguing and you're creating an impression that you are you are not understanding.
my
I
lord,
am sure you are understanding.
and lordship, lordship kindly, I may be allowed to, my lord, from the same district, same block, another judgment was passed by the planet single judge very recently. My lord.
We will not allow this to happen, whichever judgment you may show. In fact, we have serious apprehension. There is misrepresentation and fraud in your case, but we are overlooking it because there is no evidence here as such.
My lord, kindly, I may be allowed to show their affidavit, my lord. Statement of their affidavit, my lord. This is, my lord, at page 136.
You have
my lord.
5 more minutes,
Yes, sir.
whereafter we will start taking.
Thank you, my lord. Page 136, my lord.
Yes.
136 in their affidavit, my lord, they admitted that, my lord, they wrongly recorded my name, my lord, in the service book, my lord. Kindly, my lord, I may be allowed to read out, my lord. That the present petition has been filed by the petitioner internally paying for releasing his pension with effect from 1 to 2018, along with other retirement benefit, and not to recover salary paid to him due to overstaying service from 1 to 2018 to 30/11/2021. In this regard, the deponent humbly begs to state that the petitioner was initially appointed as stipendiary teacher at Mohi Datta LP School on 22/12 to 1998, and he joined in service 23/12/1998. On completion of his basic training.
That affidavit appears to be, I mean, it appears to us that the person who gave that affidavit and who said that was in cahoots with you, was in collusion with you.
My lord.
And therefore we'll say that it is a misrepresentation and fraud.
No, my lord.
Your service book was verified twice. Once in 2005, once in 2009.
Yes, my lord, but not corrected.
But every officer who verified it was going by what you said. You must have bribed them.
Kindly, my lord, another date may be fixed, my lord. Kindly. Another date may be fixed.
Another date may be fixed.
Okay.
Make a request which shall be accepted by the court. After you have argued so much and we are giving you another 5 minutes, argue. Show us everything that you want to.
Same, my lord, as per my claim, my lord, same benefit was, my lord, another colleague petitioner was given, my lord. This honorable court, my lord.
A division bench.
Single bench, my lord.
So you are before a division bench.
Yes, my
with
lord.
a judgment of Supreme Court which says that it should not be given.
Yes, no, my lord. All the judgments
सब
are,
में yes बोलते हैं.
all the, my lord, judgments are appreciated in this case, my lord. All the Supreme Court judgment.
So therefore you must be satisfied. You should be satisfied that the single judge has considered everything.
My lord,
We have read out paragraph 30 to you
30, my lord.
of State of Bihar versus Jagdishwar Pandey.
Yes, my lord. But, my lord, in this case, my lord, in the Jagdish Pandey, my lord, what I have understood, my lord, it was, my lord, provided to give him the pension from the actual date of, my lord, retirement, my lord, 2002. Actually, he was 2002 retired person, my lord, but he was given 2004, my lord. But in the Jagdish Pandey, my lord, it was provided to give him retirement from the 2002.
This is what read that. He is understanding. Read that.
From 2002, my lord. This is,
You have read this para 30
yes, my lord.
in Jagdish Pandey.
One,
Jagdishwar,
my lord, though word is used, my lord, but again it was given, my lord, to give the retirement from 28 to 2002. But here, my lord, I have given the retirement, my lord, after overstay in my service, my lord. This is, my lord, I am confused, my lord, with all respect.
You are confused
Yes, my lord.
and you want to confuse us also.
My lord, your lordship never be confused, my lord. Because here, my lord, at paragraph 7, my lord, it was, my lord, held that, my lord, his actual date of retirement is 2002. But he was given retirement in 2004. In the, my lord, last paragraph 2030, my lord, it was provided.
Indicate us the time when you are satisfied.
Yeah.
Then we will start dictating the judge.
Your lordship is if satisfied, my lord, I am always dependent.
No,
on
you
my
are,
lordship.
what should I say? We are not appreciating your arguments. Anyway, you have a superior court, go before the Supreme Court.
My lord, one, my lord, judgment recently on the same, my lord, district lordship kindly will look operative part of this judgment, my lord, single bench, my lord, with due respect, only if lordship permits me, I may.
Single judge, why? When we have a judgment of the Supreme Court and you are addressing the division bench,
Yes, my lord.
तो single judge का क्या करेंगे?
My lord, one, my lord, my humble question to me, my lord. If, my lord, it is held that, my lord, I am, my lord, overstayed in service without my fault, my lord. Again, if, my lord,
You want the court to declare that it was your fault. You want us to observe?
no, my lord, he will poor man, my lord, he
Poor man.
will be banished, my lord.
You want your pay, you have got your overstay pay, and plus you want pension also.
Calculated on that wrong pension, on that wrong overstay.
No, and he wants the pension also.
The pension he will get.
No, pension from the
That
date,
day, yes.
from 2018.
From the date when you should have retired.
That is I am praying, my lord.
The double benefit, that is what is paid.
चाहिए.
Concept of the, my lord, this judgment is that, my lord, with due respect, my lord, that, my lord, he worked and he was paid, my lord. And pension, for pension, he has to render no service, my lord. It will,
The pension will take from this. If I am already getting the benefit.
It doesn't understand.
indirectly, my lord, if, my lord,
We understand.
Anyway, I'll immediately start.
indirectly, my lord, it is recovered from my pension, my lord, because if I, my lord, worked and I paid my salary, my lord, and now, my lord, is my pension is not given, for which I have to render no service, my lord, then indirectly, my lord, it is some, my lord, extent it is recovered, my lord.
Take down. Third, Mr. A.M. Borbhuian, who appears in the state.
Lordship, I'm appearing
Lord,
for the
if
finance department, A Soliha, Lordship.
A Chaliha.
My lord, if your lordship is not satisfied, then, my lord, I will withdraw, my lord, because
Why do you withdraw? I mean, we are not.
I should not
we are-
pardon your lordship
We will
unnecessarily.
not say anything against you. We will only, against your client, we will only dismiss your appeal. We'll only dismiss your appeal. You want to withdraw, you withdraw. Well, if you get a dismissal order, you will have another opportunity of addressing the Supreme Court.
No, my lord, we will not.
We are not inclined. We are very sure we are not inclined.
My lord, kindly, can your lordship be satisfied to give me another date to satisfy?
That is not negotiable now.
Lordship, this is a case where the petitioner is asking for salary also for a certain period and pen.
We have understood it. Haven't we understood it?
Lordship,
So we have been talking as, we are talking as much as Mr. Borbhuian is
Lordship,
talking. So why do you have to repeat it?
Lordship,
You just have to register your presence,
Lordship.
that the state was here.
If your lordship is not satisfied, then I am not pressing this matter, my lord, unnecessarily.
आपको एक मौका दे रहे हैं सुप्रीम कोर्ट जाने का.
No, my lord, he will not go, very poor person, my lord. He cannot afford it.
But we are absolutely sure that we are not allowing your appeal. You want to withdraw?
My lord.
No, we will record certain things and then say withdrawal. Because you see, the difficulty is that you're not satisfied that we have understood your case. So we will first record our findings and then permit you to withdraw. So that you can check it up again. Anyway, take them. We'll not come down harshly on you. No, nothing. Whatever you have been able to get by the single judge, we shall not disturb that. though we intended to disturb that also. You were not required, the amount should have been recovered from you. And you're a teacher, how do you say that you fall in class 3? All government teachers are class 2.
My lord, not class 2 are officer category people, my lord. They are metric pass, my lord.
Anyway, we are not passing any order against the single judge. So whatever you have got, you have got. But we are recording our findings. That the reason is that you don't look satisfied that you have been heard.
Only I am not pressing, my lord, because it is.
Because if the state goes against the judgment of the single judge, I think you'll have to forgo that money also, which has been granted to you. Anyway, take a call.
My lord, I am not pressing, my lord.
After some arguments, Mr. A.M. Borbhuya, learned advocate for the appellant, seeks permission to withdraw this appeal. Yeah, in presence of learned SLPO. After some arguments, Mr. A.M. Borbhuya, learned counsel for the appellant, in presence of the learned counsel for the respondents, seeks permission to withdraw this application. Withdraw this appeal. Dismissed as withdrawn.
Obligement.
These are the counsel's name.
Item 13.
My lord, 13 may come, my lord, up in the next week, my lord.
Which matter?
It is matter, my lord, regarding compassionate department, my lord.
No. He wants to adjourn the matter. Why?
Because, my lord, my lord, I have to go from.
You have to go to before the single bench. That's why.
My lord,
Here also, if he wants. All right, we will give you a time.
next week, my lord.
Today you have not been able to cut ice with this bench, so next day. When do you want?
Next week, my lord.
And what is this matter?
Regarding, my lord, compassionate department, he was, my lord, recommended by the DLC. And when his matter is pending before the SLC, my lord. In the meantime, my lord, one office memorandum has come, my lord, abolishing the entire scheme of the.
Forget about that. That may not apply to you prospectively. But otherwise, if more than 10 years, 15 years have passed by, for whichever fault, your fault or the government's fault, we cannot pass an order.
Yes, my lord.
Father died in 2009.
9, my lord.
बहस करेंगे या you will take an adjournment?
My lord, adjournment, my lord, next week,
1 week.
For it on 4.
As prayed for, list this matter on transfer.
Item 14 and 15.
After this over. Yes, Mr. Bhuya.
My lord, rule is under challenge, my lord.
What is under challenge?
My lord, a statutory rule, my lord, which has made the person concerned who has the honors in mathematics, my lord, can only made eligible by of this rule to apply for the post of mathematics as a graduate teacher, my lord. My lord, in fact, this is a rule which has been, my lord, made. My lord, at page 19.
Mr. Bhuya, you'll have to reformulate it again.
My lord.
What is the matter? What is the issue?
My lord, the issue is that, my lord, we, the petitioners, are aspirant to participate in a recruitment process, my lord, for the purpose of our appointment as an assistant teacher, mathematics, my lord.
Assistant teacher, mathematics.
Mathematics, which is a graduate cadre post, my lord. Now, my lord,
Graduate teachers.
My lord. Now, my lord, the difficulty arises, my lord, when the initial TETCOM recruitment advertisement was issued, my lord, there was no condition has been precedent that those persons who has the honors in mathematics while pursuing their courses in the graduate degree, my lord, they can only apply. It was open for all, my lord, who has the science stream, my lord. First course mathematics holder can also apply. Now, my lord, when the recruitment process was going on by fixing that rule of the game, suddenly, my lord, the government has amended the rule, basing on which, and that rule, my lord, may be pleased to find in my first petition.
Now, first, let us see the advertisement first.
Yes, my lord, the advertisement, my lord, may be pleased to find at page 50, my lord, 50.
Yes.
Applications are invited from the eligible.
Reading which paragraph?
My lord, the paragraph, my lord may be pleased to find the condition of recruitment, my lord. The minimum educational and professional qualification for direct.
Condition of recruitment is at page 50.
Page 50, my lord, the condition of recruitment, my lord. My lord. My lord, got it, my
No,
lord.
no, we are not getting it. Page 50, it starts from your
My lord,
numbering. is
my lord,
different.
I am taking up WPC 2353 of 2025.
Oh, it was different.
That's right.
Page 50.
My lord. Kindly, my lord, at page 50, condition of recruitment, my lord. Herein, my lord may be pleased to find that the minimum educational and professional qualification for the direct recruitment in the post of graduate teacher, arts and science, my lord. For the post of graduate teacher science, my lord, we are concerned with the graduate teacher science, my lord. For in clause 2, for the post of graduate teacher science, the candidate must be science graduate or the postgraduate in science having from a recognized university with at least 50% marks in either graduation or the post-graduation or its equivalent, and Bachelor of Education from the National Council for the Teacher Education recognized institutions. So, my lord, this was the condition made for the entire cadre of science, my lord, which also includes the mathematics also, my lord. Now, my lord, what they have done, when we participated in this advertisement, my lord, we did apply.
This advertisement is of which date?
My lord, this is of dated 26th of December, my lord. 2020, my lord may be pleased to find the date at page 55 bottom, my lord, 26/12/2023, my lord.
Yes.
Now, my lord, when basing on this advertisement, the recruitment process had been initiated, my lord, we did apply under the category of clause 2 for the graduate teacher science cadre, my lord.
Yes.
Now, my lord, this process was going on, then suddenly, my lord, this addendum at page 56, annexure 3 had been notified, my lord, wherein, my lord, may be pleased to find the cutoff has been made, my lord. In the science category or in the arts category, how many numbers of posts of all total out of 7,249 vacant posts, they have made it clarify by this addendum. They have said that graduate teacher science 2,111 and the mathematics is 1,737 numbers, all come down to 8,400 numbers of posts, my lord, including science and arts. So, my lord, we were expecting that we will be considered in the mathematics also. But, my lord, the problem is that, my lord, when the recruitment process was continuing, my lord, may kindly turn to page 99, my lord. My lord, may kindly turn to page 99 and note the date of this notification, my lord. My lord, this notification dated is of 23rd of August 2024, my lord. By way of this notification, amendment of schedule 2 of the rule 2 has been made, my lord, in the of the principal rule, my lord. In the principal rules, in the schedule.
In exercise of past conference period.
My lord. Provided that a graduate teacher, mathematics, shall have a graduation degree in science with honors or major in mathematics and having physics, chemistry, or biology as a first course or the minor subjects in the graduate level courses or the post-graduation degree in mathematics from a recognized university with honors or major in mathematics, having so and so subject with at least 50% marks in so and so.
This is of 23. 26, 20.
My lord.
This law has come on 24, 11th September 24. But in this case, it will have to be acted retrospectively. Changing the rule of the game, there are various judgments.
My lord.
Especially if an act is made under the proviso to Article 309 of the Constitution. Not in all cases, it has to act prospectively. Not in all cases. So the rule, general rule is prospective. You have to check up the law. We'll also issue notice.
My lord, notice has already been issued. My lord,
yes.
my lord, what has happened, my lord, the recruitment process is going to be over very shortly, my lord. And the first round of, my lord, the merit list has already been published. And today is the, my lord.
So you never applied, you could not have applied.
No, my lord, we applied in the graduate teacher
So
cadre, my lord.
you must have been permitted to appear for science.
Only
generally,
science, my lord,
not
not in mathematics, my lord, not in mathematics. So, my lord, we have been deprived from a fair participation of a recruitment process, my lord.
Mathematics.
My lord,
What have you responded? What have you said?
no affidavit, my lord.
My lord, give me a week time, my lord, we'll file it.
Ask Mr. Psychiatrist here, this is.
Yes, my lord.
Get all the judgments.
Yes, my lord.
Judgments from, if you don't find from Supreme Court, you can find from Patna High Court, many judgments given by us. In this case, retrospectivity will not apply.
My lord,
Nonetheless, we'll see.
my lord, I have also a little bit of, my lord, knowledge, research had been done regarding this change of the rule of the game, my lord.
Why, you are supposed to have better researched
No, my
papers.
lord, from my very limited source, I will try to satisfy my lord, my lord, my lord.
Please. File your affidavit.
Yes, my lord.
My lord, may I pray that, my lord, in the meantime, my lord, for the mathematics, the result may not be declared, my lord. Otherwise-
We don't do that, especially because the process of whatever, they are not going to fill up all posts. They will not get many.
Because, my lord,
And many would be sailing in the same boat.
yes, my lord,
Many would be sailing, so don't worry.
my lord.
Take note. Mr.
Over.
We have heard Sri A.R. Bhuyan, learned advocate for the petitioner. And Mr.
NZ Khatunier.
N.C. Khanuya for the.
MJ.
MJ Khanuya for the,
Because-
for the Department of Education. A challenge has been put up to the amendment in the Assam Secondary Education bracket Provincialized Schools Service Rules 2018. By virtue of proviso to Article 309 of the Constitution of India, whereby it has been clarified, whereby it has been provided that a graduate teacher bracket mathematics shall have a graduation degree in science with honors or major in mathematics and having physics, chemistry or biology as pass course or minor subject in the graduate level courses or post-graduation degree in mathematics from a recognized university with honors or major in mathematics, having physics, chemistry or biology as pass course or minor subject with at least 50% marks in either graduation or post-graduation. If you miss out on anything, just refer to page 99 of the brief, you will find it. Mr. Bhuya has drawn the attention of this court to the fact that an advertisement was issued for filling up 7249 vacant posts of teachers, including mathematics teachers, on 26/2/2023. In the aforementioned advertisement, the minimum educational and professional qualification for direct recruitment in the post of graduate teachers bracket arts and science was also stipulated. For the post of graduate teacher bracket science, a candidate should be a science graduate or a postgraduate in science from a recognized university with at least 50% marks in either graduation or post-graduation bracket or its equivalent, and Bachelor of Education bracket B.Ed from National Council for Teacher Education, National Council for Teacher Education recognized institutions. Thus, the advertisement only provided that a desirous candidate for becoming graduate teacher in either arts or science may apply, and for science stream, the only requirement was graduate or postgraduate with specific percentage of marks along with B.Ed degree. Thereafter, an addendum was brought out on 27/12/2023.
It is 16/10/24.
Sorry, on 16, not on, oh, sorry, on 16/10/2024. Clarifying the number of posts. The number of posts for graduates, teachers in science was fixed at 2111. Whereas for graduate teacher in mathematics, 1737 number of posts were earmarked. This created some confusion in the mind of the aspirants, including the petitioners, who had applied pursuant to the advertisement on the assumption that the only educational qualification required for graduate teacher in science, including mathematics,
Well,
would be graduation or post-graduation with 50%. First up, in that case, a special category of mathematics teacher, a special category of graduate teacher in mathematics meant that perhaps there would be some classification in the matter, in a classification for the purposes of classification in the educational qualification, in the threshold educational qualification for applying for a graduate teacher in mathematics, in the discipline of mathematics. The confusion was confirmed with the amendment in the Assam Secondary Education Provincialized School Service Rules 2018, whereby graduation in science with mathematics honors was made the minimum qualification for obtaining appointment, for participating in the recruitment process for graduate teachers in mathematics. With this amendment, Mr. Bhuyan, learned advocate, argues that the entire rule of the game with respect to the appointment/recruitment has been changed, which is impermissible. He, however, does not question the validity of the amendment.
no, we have also questioned.
How can you question the validity of the amendment? For that, you will have to do different exercise. I'm dictating something else.
Mal,
He, however, does not question the validity of this amendment, but simply suggests that in the recruitment process which was initiated prior to this amendment,
Mal,
this amendment should not be applied retrospectively.
Mal,
Don't expand the scope of your
Mal,
only this much we'll see.
Mal.
Let an affidavit on behalf of the Education Department be filed positively by the next date. 2 weeks.
Yes, my lord, may I pray on the first week of August, my lord?
First week of August. First week of August will be too
Yes.
short. I don't think they will be able to do
Because,
it.
my lord, if in the meantime selection is going to be over.
No. Mathematics, so many posts, they are not going to conclude it. Yes, you do it as early as
Yes, yes,
possible.
sir.
File your response, give a copy in advance to
Yes,
to Mr. Bhuyan
Yes,
for him to
yes, sir.
rejoin. Again, the affidavit and an advance copy of the affidavit of the response affidavit be served upon the counsel for the petitioner to enable him to rejoin if deemed necessary.
Mal.
11/8.
Obliged, my lord. Highly obliged.
Okay.